So, as we already said and discussed, we are first going to read one more time the concept of dictionary definitions. What is the importance of a dictionary definitions with regard to the act? So, listen carefully. First, let us sum up everything and try to understand clearly. Explain how dictionary definitions can be of a great help in interpreting or constructing an act when the statute is ambiguous. Ambiguous means unclear. Ambiguous means unclear. Okay. Let us first try to understand this. Dictionary definitions. Sir, what is this dictionary definition concept all about? As you already know, okay, already you know this concept, but still, let me first explain the concept one more time and try to complete this. First 5 questions I will repeat once, okay? Then after the speed will pick up, you can easily understand because the reason I am telling you one more time, it's a 10 marks chapter in exam. Don't leave. 10 marks in exam. After this general clauses act also I will discuss. That's another 10 marks. FEMA 8 to 10 marks. 3 chapters. Tambola 30 marks area. So don't leave. Okay, including choice. Each and every chapter will come for 10, 10 and 10. So 30 marks area, no one will leave. Are you understanding the point or not? So please, let's concentrate properly in this. Listen carefully. First point number 1. Dictionary definitions, as you already know this, okay, but still I am repeating, listen carefully. First one is the dictionary definitions. Whenever you wanted to know the meaning of a particular term inside the act, first try to read that particular act itself, go to section 2, refer the definitions. If that word is not defined anywhere in the definitions, read explanation to the section if there is any. Sir, explanation also not there, sir. It's not defined. So, if a particular term is not defined anywhere, means what? In the act, it was not defined anywhere. Where the word is not defined anywhere in the act, one can refer the dictionaries. One can refer the dictionaries. But in the dictionary, what you will find, how that word is generally sensed, you will know. That is commonly what people will read, that only will be there. But you need to understand one point. You go to a dictionary. Open that. See a word. See the word. For that word, they will give alternative meanings. Like this, this is another meaning, this is another meaning, like that. 10, 15 meanings will be given. In that, which one you have to pick, that should be extremely careful. Okay, so therefore point number 1, whenever the term is not defined within the act, okay, within the act means I mean definitions, explanations, rules, etc. If a definition is nowhere defined within the act, that means if you wanted to refer a particular word within the act, it should be defined in the act. If not defined in the act, then go to the dictionaries to know the general meaning in which it is commonly used. However, care should be taken to pick up which is the correct meaning for that word, because several words will have one word can have several meanings in dictionary. Picking up a right word is your care. Understood the point or not? From the context in which you are reading, you should pick the word. Okay, next one. Very, very important thing is dictionary can define some words. Sometimes court will define the word. Sometimes what will define the word here? Court will define the words. In a particular case, court will define this is the meaning of this word. Court will define. When court defines a term versus dictionary, the same word is defined, which should be given more weight. Definition given by the court to that word should be given more weight than the dictionary definition. This is what we already discussed. Okay, so I repeat one more time. Point number 1, question came in exam, how to write. Number 1, first we need to refer the act for a particular definition. If the act is silent about the definition, then one can refer the dictionaries to know its common sense, means general sense in which it is commonly used. But when you are seeing several meanings for the same word, care should be taken to pick such word which gives a right meaning. Number 4, when a particular word is defined by judicial decision, the meaning of the word is defined by the judicial decision, it should be given greater weight than that of the meaning furnished by the dictionaries. Okay, for technical terms you should refer technical dictionary. You might know this already. Okay, technical terms means whenever there is a scientific word, scientific words should be given their scientific meaning only. Okay, so you can read. First, we refer to the act in question to find out any particular word or expression defined. Where we find that a word is not defined in the act, we may refer to the dictionaries to find out the general sense in which it is commonly understood. However, in selecting one out of several meanings of a word, we must always take into consideration the context in which it is used. Okay, this line not required. From here again read. Further judicial decisions and court decisions laying down the meaning of the words in construing the statutes in paramateria will have greater weight than meaning furnished by dictionary. Meaning of a court will be more than meaning furnished by dictionaries. Technical terms ki refer technical dictionary. 1 point over. Okay, next. Explain the mischief rule for the interpretation of a statute. Also give the four matters it considers in construing an act. As already known, but I will reinforce the concept one more time. Listen carefully. What is this mischief rule? What is this mischief rule? Okay. First point number one, concentrate properly. From here, we will take a speed and pace and try to complete this. Listen carefully. These all are repetitions. You might have already known this, but still I am repeating this in order to reinforce the concept and concretely build this particular concept. Exam, if it comes, no mistakes committed. Okay. Number one, mischief rule. When the language used in the statute, is capable of giving two or more meanings, one should follow the judgment given in the headens case. Listen again. Where language used in the statute is capable of more than one interpretation, then the principle laid down in the headens case must be followed. Okay. This concept of mischief rule is also called as a purposive construction. And a construction here, purposive construction. Okay. So what does it mean? This, whenever there is a particular term which is having two ways of interpretation, okay, you should go with that interpretation which will suppress the mischief. Mischief here represents undesirable result. Okay, mischief means not children mischief, as I already said. It is not, mischief does not represent children mischief, all those mischief means wrong meaning. So suppress the wrong meaning, advance the remedy means come with a better solution for that word. When the words used in the section are complicated, when the words used in the section are confusing, when the words used in the section are giving 2-3 meanings, which meaning you should give? You should give such a meaning which will suppress the mischief and advance the remedy. Like that only you should write in exam. If you write some other language giving the same meaning, they don't give you marks. I am telling you very, very clearly. Okay, there is no chance. They don't give marks. I say don't give you marks if you do like that. You have to write as it is. Suppress the mischief, advance the remedy. What is so great about remembering? Easy to remember. When a particular word is having 2-3 interpretations, follow Haydn's rule. 1 point. Point number 2. This is also called as purposive construction, also called as beneficial construction. Also people will call. Point 2. Point number 3. Whenever a particular term has 2-3 interpretations given, okay, court should adopt such construction which shall suppress the mischief, advance a remedy. Okay, next. What is said in Haydn's case? Listen. Whenever a particular term has 2-3 meanings assignable, okay, when a particular word has 2-3 meanings assignable, means for a particular word I can give 2-3 ways of interpretation. In that case, court has to give a right interpretation for the words used. What is right interpretation for the word? 4 questions you have to answer. What was the law before making an act? What was the law before making an act? So law and act both are same, na? No. As I said already, law and act both are not same. This law is not company law, income tax law, GST law. Law means general rules. Traditionally what people are following. See here. Generally, whenever something is done, act to stop that, they will write an act. For example, companies related party transactions are entered. Which transactions here? Related party transactions are entered. And they are not telling to the shareholders also. When they enter into related party transaction. Just like that, they are entering Satyam scam happened because of that. Related party transactions. Okay, therefore, previously, traditionally, if you see, people are not disclosing their related party transactions properly. Okay, so that's the first one. What was the law before making an act? Before this Companies Act 2013 came, law means generally what the rule of law, generally what the people are following is they will enter into related party transaction but they do not disclose to anyone. This is law before the act. Law means general principles people are following. Okay, what was the mischief or a defect? Mischief means nonsense here. Okay, what is the mistake or a defect for which law did not provide? Previous Companies Act did not provide for strict regulations on related party transactions. This one. What is the remedy that an act has provided? The remedy that act has provided, the act of parliament, Companies Act has provided is, whenever you enter into related party transaction, whenever you enter into related party transaction, disclosure to shareholders is mandatory. Okay, next, why this point came? There is one section called as a related party transactions 188. They said, if company enters into contract with a related party, if a company enters into contract with a related party, whoever are related to him cannot vote in the general meeting. Okay, if a company enters into contract with a related party, they cannot vote in the general meeting. Generally resolutions are there na? Generally resolution, ordinary resolution, special resolution. Related party transactions whenever come to the general meeting, ordinary resolution has to be passed. Example, if I am the director, okay, my brother, he is not a director but he is a member. Okay, both of us are members but I am a managing director, he is not a director. Both of us are sitting in the meeting. Now, they said related party cannot vote. Related party cannot vote in the general meeting. Now, question arises. Company entered into contract with my brother, not with me. Okay. Now, who cannot vote? He cannot vote. I cannot vote. Both cannot vote. Now, one word. Related party cannot vote means here question. Actually, company entering into contract with him. Okay, he is a related party to me. Therefore, he is a related party also to the company. Director or his relative. Director is a related party to company. Director relative is also related party to company. Okay. So, what section said? Section said, if a related party transaction is being entered, such related party cannot vote. Contract is entered with my brother. He cannot vote, I cannot vote, both cannot vote. Now, one word, such related party cannot vote. But which related party? One word has double meanings now. Two meanings, three meanings are coming. Which one should be given? What is the law before? Related party transactions sections before that. What is the situation in India? Whenever related party transactions are happening, directors are not even telling the members, generally they are doing it. That is law before that. Second, what is the mischief? Law does not provide no strict regulation. Number three, what is the remedy that Companies Act has provided? Strict regulations on related party. Therefore, what is the reason for remedy? Neither the main director or his related party with whom contract is entered, if you are a related party, don't vote. Therefore, the intention of law is very clear. After so many scams happened in India, related parties should not be allowed to vote. Okay, you need not be the person with whom contract is entered. Director, relative of director, company entering into transaction with relative of director, he is a director come member, he is only a member, he cannot vote, both cannot vote. That's how you need to interpret. Okay, that's it. Everyone, please reply understood or not. Next, what is the principles of grammatical interpretation? This question came for 8 times in exam. As I already said, okay, this question came for 8 times in exam. Okay, there are totally 25 questions in this chapter. In my book 65 are there. All are repetitive in nature. Though repetitive, I just wanted to tell the importance. That's why I kept all the questions in the book. Okay, but technically there are around 25 topics in this chapter. 25 topics, if you can understand properly, done. You need not do anything else more than that. Let's see. What is the concept here? concept of grammatical interpretation. Concept of grammatical interpretation. Okay. First listen carefully. First listen carefully. There are, and see here. What are explain the principles of grammatical interpretation, logical interpretation. Two things he is asking. What is logical interpretation? What is grammatical interpretation? Let's try to understand. Okay. See, whenever we are going to interpret anything, there are two types of interpretation. Number one, grammatical interpretation. Second one, logical interpretation. Number one, grammatical interpretation, logical interpretation. I repeat one more time. In order to ascertain the meaning of any law or a statute, okay, there are two principles of interpretation. Number one, grammatical interpretation. The word grammatical interpretation is also called as literal interpretation. What is it? Literal interpretation. And second one is a logical interpretation. Logical, again, 5 branches are there. Number one, reasonable construction, beneficial construction, harmonious construction, exceptional construction, ejusdem generis. These 5 are logical interpretations. Okay. On the other side, there is one more called as a grammatical interpretation, called as a literal interpretation, Okay. So first line. In order to ascertain the meaning of any law or a statute, you have two principles: principle of grammatical, principle of logical interpretation. Okay. Okay. Next, why you make interpretation? Two purposes. First one, real meaning of the law and intention of the legislature. Legislature means lawmaker. Parliament is a legislature. Okay. Parliament approves the law. Na? Sir, Parliament will approve the law. So Parliament will be treated as the lawmaker. Okay. Sir, Parliament la MPs are there. They don't write na. They don't write. Taj Mahal is constructed by Shah Jahan. Shah Jahan need not construct. Masons will construct. But name will be given to him na. Who is the person who constructed Taj Mahal? No one will tell all the list of masons who brought the bricks and cement. At that time cement not there. What are the things you used? We will tell Shah Jahan only. Same way, law drafted by experts. But who does it? Under whose guidance? Legislature, parliament. Okay. So lawmaker means parliament always. Law interpreter and constructor will be court. Court interpret the law. Parliament write the law. Interpretation is a bridge between both of them. Okay. So in order to ascertain the meaning of the terms in a law or a statute, you have two types of interpretation. One is grammatical, second one logical. Okay. Next, why a purpose? To understand the real meaning of the law and to understand the intention of legislature. 2 points over. Okay. Next, sir, what is the meaning of grammatical interpretation? What is the meaning of logical interpretation? Grammatical interpretation means name lone clear. I don't give much effort on that. Grammatically, as per English language, what is the meaning of that word? That I will read and I will continue. For example, every company shall hold first annual general meeting within 9 months from the close of first financial year. What is great in that? Every company, all the companies shall mandatory hold, they should conduct AGM, annual general meeting. Okay, within 9 months means not more than 9 months from the date of from the close of first financial year. That's it. This is called as a grammatical interpretation. There is nothing to unnecessarily doubt about that section. So therefore, when the words of the section are very clear and plain, go by grammatical interpretation. Grammatical interpretation means what? Grammatical interpretation concerns itself exclusively, means only with the verbal expression of law. Verbal means what they said. For that I will give English meaning. I will continue. Verbal expression. So grammatical interpretation, whenever you are writing an exam, first thing what you should write, grammatical interpretation concerns on verbal expression of law. Okay. Next, while logical interpretation goes beyond the verbal expression of law, goes beyond the letter of law means verbal expression of law, whereas grammatical interpretation does not go beyond letter of law. Logical interpretation, on the other hand, seeks more satisfactory evidence of the true intention of the legislature. Means just giving the verbal meaning of the word, grammatical interpretation. Okay. Go understanding the intention of the legislature and giving the meaning accordingly, which may not be sometimes as per the verbal expression of law, is called as a logical interpretation. Generally, tell me, what is this? May. What is this? Shall. This is mandatory force. This is directory force. Mandatory force means one must do. Directory force means one may or may not do. But some this is grammatical interpretation. May verbally what do you mean by may? May means you may do, you may not do. Okay, it's a directory. Okay, I am directing you. You can do in a different way also. Shall, must you should do. It's not directory. It's a mandatory provision. Okay, generally this is the grammatical meaning. As per English, may means optional, shall means mandatory. That's it. This is verbal expression. This is a grammatical interpretation. However, sometimes when the law is getting defeated, if you use like this, then court will seek to interchange them. May will be read as shall will be read as may. That's called as a concept of logical interpretation. Logical interpretation means I will go by more by the lawmaker's intention, not by the verbal expressions. Okay, in other words, emphasis in grammatical interpretation is on what law says, but logical interpretation concentrates on what law meant to say. Okay, next, application of principles in the court. What principles court will apply in grammatical and logical interpretation? In all ordinary cases, I told you, generally grammatical interpretation is the sole form allowable. Okay, court cannot delete a word, court cannot add a word, court cannot modify a word. It cannot add, it cannot delete, it cannot modify. Generally, however, if a letter of law is logically defective due to any reason, by reason of ambiguity, inconsistency, incompleteness, court is under the duty to travel beyond the letter of law to determine the true intention of the legislature. True intention of the legislature. So, that a statute is enforceable at law, however unreasonable it may be, the duty of the court is to administer the law as it stands rather than it is just or unreasonable. So understand, technically these need not be written in exam. Up to here you have to write. So what are all the points? Okay, if you want you can write down the notes also. Fastly I will tell, because this question came for 8 times in exam. Again there is a chance that it can come. So don't take a chance. Okay, so please write down point number 1. Whenever grammatical interpretation comes, or at least do one thing. If you have the question bank with you, the important points I will spotlight. Okay, first, in order to ascertain the meaning of any law or statute, there are two interpretations, grammatical and logical interpretation. That's one point. Point number 2, what is the purpose of this interpretation? Understand real meaning and intention of the law. This is second 2A, 2B. That second point, what is the purpose of that interpretation? Real meaning of the law and intention of the law. Next, grammatical interpretation concerns on verbal expression. Okay, it does not go beyond the letter of law. Logical, this is third point. Logical interpretation, okay, seeks more satisfactory evidence on true intention of legislature. This is 4. This is 4. Grammatical interpretation concentrates on what law says. This is 5A. Logical interpretation concentrates on what law meant. 5B. What court will do? Ordinarily, court will go by grammatical interpretation. Okay? 6. Seventh point. Court cannot add, delete, modify the law. However, if it is logically defective, 8th point, due to ambiguity, inconsistency or incompleteness, then court is under duty. Court has a duty now. It's obligation on the court to travel beyond the letter of law so as to determine the true intention of the legislature. That's a point number 9. These 9 points if you write, then they will give you that 5 marks in exam. Okay, done. Everyone reply. Are you all satisfied and understanding the concept of interpretations properly? So I am putting the answer before you. 2 minutes time I will give. Read it properly. Most important, mark it, very important for the exams. Completed? If you say you are done, we will be going into the next one. Okay. So let's continue with the next one. So next one. Explain natural and grammatical meaning helps in interpretation of statutes. Explain natural and grammatical meaning helps in interpretation of statute. MTP 6 marks, May 2018. See here. Sir, what is natural and grammatical meaning? That is, the previous question is, don't get confused between the questions. Previous question is grammatical meaning versus logical meaning. Grammatical interpretation versus logical interpretation. This is natural and grammatical meaning. So, what is natural and grammatical meaning? Question will arise or not? Listen. First point number one. Whenever there is a particular word used in the act, first we should try to understand that word in its natural, ordinary, and popular sense. See, I will write here. You should understand in a natural, ordinary, or a popular sense. Means what? Naturally, what is the meaning? That meaning you should give. Or ordinarily, what generally people will use that. Or popularly, what it is meant to be. Generally, what people will call. Give that meaning. So, first thing, statute always you should first understand in their natural, ordinary, and a popular sense. Okay, and it should be construed, means understood according to their plain, literal, and grammatical meaning. Plain, literal, grammatical meaning. I repeat one more time. What meaning we should give, in what way we should understand. Okay, you should understand in a natural, ordinary, and a popular sense. Okay, and you should interpret in a plain, literal, and grammatical way. You should give that meaning. It must be construed according to their plain, literal, and grammatical meaning. If at all, giving a natural meaning, ordinary meaning, popular meaning, and understanding in a plain sense, literal sense is resulting in inconsistency, means giving a wrong meaning for the words. In that case, okay, with any express intention or declared purpose of the statute, or it involves any absurdity, if giving a plain meaning is giving rise to inconsistency or giving rise to absurdity, means nonsense meaning, repugnancy or inconsistency, the grammatical sense must be then modified or extended or decreased, abridged, only to avoid such inconvenience, but no further. Okay, how to write this in exam? That's the main concept that we need to concentrate now. First one, question comes like this. Grammatical, natural, and grammatical meaning helps in interpretation. First, whenever the words are used in the statute, one should understand in their natural, ordinary, and popular sense, such that it should give a plain, literal, and a grammatical meaning. Normally in English, what is the meaning? That meaning only should be given to that. If there is an inconsistency with any express intention, if there is any inconsistency, absurdity, repugnancy, then grammatical sense should not be given. It should be either modified, or you should give more meaning, extended meaning for that, or you should give a lesser meaning for that to avoid such inconvenience. Okay, one case law also happened. A case law must write in exam. This is a study material case law. In the study material it is there. There is a scientific leaf called as a beetle leaf. Okay, beetle leaf will be there na, pan, beetle leaf. Beetle leaf is a general word we will give, and popularly we use the word beetle leaf. Actually, when you open the dictionaries or something, legal dictionaries or something like that, beetle leaf word is not there. Okay, it is not defined in the way. So what happened in a question before the court, whether the sale of beetle leaves was subjected to sales tax or not is a question. Generally, sales tax is attracted also on the sale of certain agricultural commodities. Sales tax is there. On beetle leaf, it will be there or not is a question. So one should first understand what is a beetle leaf. Okay, beetle leaf has a scientific term. Has a scientific, as already said so many times, sir. You call it a rose. Scientifically, it will be called in a different way. You call it hibiscus. Scientifically, there is a different name for that. Are you understanding or not? Anything scientific name is different. General popular word is different. Okay, generally people call that leaf as a beetle leaf, but what really it meant to say, that meaning is not used. Beetle leaf means whatever the popularly people know beetle leaf as, you will use it for normal consumption. That leaf only we need to consider. So, in the question before the court, whether sale of beetle leaves was subjected to sales tax. In this matter, Supreme Court held that beetle leaves could not be given dictionary or technical or botanical meaning. Okay, beetle leaves should not be given, okay, dictionary meaning or technical meaning. Why? Are beetle leaf popularly people know beetle leaf in one way, apply only that meaning. When the ordinary and natural meaning is clear and unambiguous, so when you need not give technical meaning or botanical meaning means as per the science, you need not give that. When the ordinary and the natural meaning is clear and unambiguous, being the word of everyday use, it must be understood in its popular sense by which people are conversant with it, as also the meaning which the statute dealing with the matter would attribute to it. So, beetle leaf. Okay, the word beetle leaf is not popularly defined in the dictionary. Beetle leaf, different types are there. Which beetle leaf plus sales tax you are talking? Am I clear? For example, beetle leaf, if you check in the dictionary, they will give one meaning. In that, there are different kinds of leaves will be there. But which leaf is subjected to sales tax? They said all kinds of beetle leaves are not subjected to sales tax. Which is popularly used for human consumption in a real life, that meaning only should be given to that. Therefore, sale of beetle leaves was liable to the sales tax. Clear? Which beetle leaf? What we are generally using today. Not the technical, scientifically what they defined is not important. Generally, popular sense what people are using, that you should do. That's how natural and grammatical meaning gives more important to sum up everything for your understanding. Okay? What you have to write in exam? What you have to write in exam? First point number one. Whenever the words are used in a statute, they should be given a natural, ordinary, and a popular meaning, such that what should be construed? Plain, literal, and a grammatical sensely you should interpret them. Number two, if plain and literal and grammatical interpretation leading to inconsistency, repugnancy, absurdity, etc., that grammatical sense should be either extended, modified, or abridged, decreased, okay, to avoid that inconvenience. Then example, in a Supreme Court case law, court said that the word beetle leaf should be given the grammatical and okay, popular sense as what we see in our daily life, not as per the technical, botanical, or scientific meaning. That's it. Answer is over. 6 marks will be yours. Everyone reply, understood the point clearly? Everyone in the class? Everyone understood? Reply. All the participants, whoever are participating, please reply. Everyone understood clearly? Next. Explain the meaning and application of the rule of harmonious construction in the interpretation of statutes. Okay? Harmonious construction. Okay. First, what is harmonious construction? This also we already said here, but still, point number one. Harmonious, how to present in exam is an important thing now. Let's understand what is harmonious construction. Okay. See here, harmonious construction means two types of sections will be there. I repeat, two types of sections will be there. When two types of sections are there, two sections are discussing about same subject matter. Same subject matter means what? I will explain this way. There are two provisions. Two provisions are talking about a same thing. There is a conflict between both the provisions. Which one to apply question has come. One should always understand two sections are there. Which section is more important if that question comes, if you tell this is important, then lawmaker won't write that first one itself. When lawmaker has written a particular section, it means every single provision is equally important. There is no concept of this is more important, this is lesser important, these all we will do. Lawmaker don't have that, because lawmaker don't prepare the law for writing exams. Exams ki you can tell this question came 4 times, this question came 1 time, this is more important than this. But lawmaker ki for exam purposes they don't write law. They will write law to administer a particular area. For them every section is equally important. When every section is equally important, how come one section will kill another section? Therefore harmony means dispute should not be there, friendship should be there. One section and another section should be given equal friendship. No section should kill another section in tension, because if really one section can kill another section, lawmaker don't write the first one. So on that premise, a concept came which is called as a rule of harmonious construction. Rule of construction here, harmonious construction. So let us first try to understand what is this rule of harmonious construction. Okay, see, whenever there are two provisions, first listen carefully to the general meaning, after that you can read text of the study material. Whenever there are two provisions are discussing about the same subject matter, okay, there exists a conflict. Whenever there is a conflict between two provisions, you should resolve the conflict between both of them and apply both the sections, because if only one section has to apply, lawmaker don't write the another. If he has written, you should give importance to all the sections, apply both the sections. If you cannot harmonize, means you cannot apply both the sections, in some cases specific section should prevail over general section. Specific section should prevail over general section. How? Let us read what is given in the study material first. Okay, when there is a doubt about meaning of the words of a statute, these should be understood in the sense in which they harmonize with subject of the enactment and the object of the legislature had in view. Where there in an enactment two or more provisions which cannot be reconciled with each other. Reconciled means both cannot be applied each other at the same time. They should be so interpreted as to give effect to all of them. That's what I said. Whenever there is a inconsistency where reconciliation is not possible, you should give effect to all the sections, both the sections. This is what known as a rule of harmonious construction. Okay, next. I told you just now, act when it is passed, all the sections are equally important. One section they don't write. First section 1 approve in the parliament, section 2 approve in the parliament, okay, section 3 unimportant, like that they don't. Full act will come in one go. Full act when it is written, every section is important. Yeah, it must be always borne in mind that a statute is passed as a whole and not in sections, and it may be well assumed to be animated by one general purpose and intent. The court's duty is to give effect to all the parts of the statute if possible, but this general principle is meant to guide the courts in furthering the intent of the legislature, not overriding it. Application of the rule. The rule of harmonious construction is applicable only when there is a real and not merely apparent conflict between the provision. Must be a conflict between the provision. Real conflict should be there, and one of them has not been made subject to other. One of them had not been made subject to other. When after having construed in the context the words are capable of only one single meaning, the rule of harmonious construction disappears and is replaced by the rule of literal construction. When there are two meanings that can come, then only harmonious construction has to be taken. If two sections are there, two sections are discussing about two different subject matters, there can't be conflict or anything, inconsistency not there, only one meaning can be given, then literal interpretation only will apply, harmonious interpretation will not apply, it will disappear. Like this you have to remember, na, it become difficult. Okay, I will dictate notes in a easy way, please write down somewhere. Okay, if in exam it comes how to write the harmonious construction, I will show you an example also once you write down. Okay, write first. Point 1, keep the heading rule of harmonious construction. Mark it important, 6-7 times came in exam already. Keep the heading rule of harmonious construction. Rule of harmonious construction. Point 1. Point 1. Point number 1. When there are two or more provisions, when there are two or more provisions which cannot be reconciled with each other, which cannot be reconciled with each other, which cannot be reconciled with each other, they should be interpreted, they should be interpreted in such a way to give effect to, such a way to give effect to all of them. Full stop. This is known as rule of harmonious construction. Okay, point number 2. One should remember that a statute or the law, is passed as a whole and not in sections. Passed as a whole and not in sections. Okay, and the entire act has one general purpose and intent. And therefore, it is the duty of the court, to give effect to, effect means importance, to give effect to all the parts of the statute. Okay, next one. Point number 3 or 4 or whatever the case may be, write down. Application of the rule. Underline. Application of the rule. Underline. Below write down A. There must be two provisions. There must be two provisions. There must be two provisions. Okay. In the brackets write down minimum. In the brackets write down minimum. Okay. There must be two provisions. Point B. There exists a conflict between those provisions. Underline the word conflict. There must be a conflict between those provisions. There must be a conflict between those provisions. Next point, C. There must be a real There must be a real and not merely an apparent conflict. There must be a real and not merely an apparent conflict. Apparent conflict. Next points. D. 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 Try to resolve the conflict. Try to resolve the conflict. Try to resolve the conflict and give effect to both the sections. Try to resolve the conflict and give effect to both the sections. Both the sections. If we could not harmonize both the sections, if we could not harmonize both the sections, specific section should prevail over. Specific section should prevail over general section. Specific section should prevail over general section. Last point, point number 4 or 5 or 6 or something is there, na? Write down. Non-application of the rule. Non-application of the rule. Okay, that means when harmonious interpretation should not be applied. Okay, when harmonious interpretation should not be applied. Okay, write down A. Point A in that. Okay. Okay, point A, write down. When the words are capable of only a single meaning. When words are capable of a single meaning. When words are capable of a single meaning, means there is no confusion, there is no ambiguity. It's very clear, there is only one meaning for that. When the words are capable of a single meaning, harmonious construction disappear and it is replaced by literal construction. Harmonious construction disappears and it is replaced by literal construction. Okay, B. One section is made subject to other. One section is made subject to other. Sir, everything is understood, sir, but this subject to other I did not understand. I will give you examples also, yeah. One section is subject to other. That's it, yeah. That's it. Entire answer is over now. But before that, everyone, please tell me, have you written and understood all the concepts up to here clearly? Everyone. Okay. Now listen. I will give you some examples relating to harmonious construction. Examiner they can ask. See here. I will show you a live example for you to understand. I will take one example called as general meeting. Annual general meeting. This question was tested in exam for 6 marks already. So I will take this example. Every company other than one person company shall in each year hold in addition to any other meetings a general meeting as its annual general meeting and shall specify the meeting as such in the notices calling it, and not more than 15 months shall elapse between date of one AGM of the company and that of the next. Okay, next. Provided that in case of first annual general meeting, it shall be held within a period of 9 months from the date of closing of the first financial year. and in any other case within a period of 6 months from the date of closing of financial year. Like that they said some statement. Here various provisions are there. Subsection 1 is there, in subsection 1 2 points are there, proviso is also there, variety provisions are there. Okay, let's understand this. What they said, three conditions they said. How to conduct the meeting? They said one by one like this. Date number 1. Each year one meeting must be there. One AGM in a year. One AGM in a year. They use the word year, not financial year, calendar year. Year means. Okay. Next, regular classes I used to tell that I used to take half an hour time and explain this. Year means year, a calendar year. Financial year means financial year. That's all. Okay. Don't interpret and synonymously use both of them. That's a different interpretation. This is not the time to learn about them. Next, one AGM in every year. That is one condition. Next, not more than 15 months shall elapse between one AGM and that of the next. Gap between two AGMs should not exceed 15 months. Number 3. First annual general meeting should be held within 9 months. But any other case other than first annual general meeting, within a period of 6 months from the close of the financial year. Three conditions they kept. Now how to interpret this? There are multiple provisions. Multiple provisions la multiple dates are coming. Example I will tell you. I conducted my second AGM on 12th September 2024. 12th September 2024 I conducted my second AGM. My company incorporated 2 years back. First AGM over. Second AGM I conducted on 12/9/2024. Now when should I conduct the third AGM? What is the last date, due date? Question arises. Now when there are three provisions, three conditions or three provisions, okay, all the three are not subjected to one another. One condition is not linked to three independent conditions are there. Okay, three independent conditions means one gives one date, another gives another date, third gives third date. Really, sir? Let's check. One AGM in every calendar year. Which year you conducted? 24th you conducted one meeting. Now next calendar year will be 25. For that one meeting should be held. So last date will be 31/12/25. Number 2. As per this 31/12/25. Okay. Now. So gap between two AGMs should not exceed 15 months. When you conducted last meeting 12/9/24. 12/9/24 to 12/9/25 1 year. 12 months. Another 3 months. Okay. December. So it will come to 12/12/25. 12/12/25. Next. After that, 6 months from the close of the financial year. Already for 31/3/24, you conducted this meeting. 31/3/24 financials are put in 12/9. Next financial year is what? 31/3/25 you should conduct AGM. From this 6 months you need to add. So 39/25. 39/25. So now everyone in the class, tell me. This is in your syllabus, general meetings chapter. Now everyone answer. Three provisions are giving same answer, different answer. Everyone. Three provisions are giving same answer, different answer. All the three are giving same answer or a different answer. Ade problem. They should not give different, but it is giving a different meaning. Yeah. Then what to do? How to interpret? There is a conflict. If you tell first point is right, then the meeting will become 31/12. Then second and third will tell you are wrong. There is a conflict. Inconsistency is there. Second, if you follow If you follow second, first and 3 will tell you are wrong. If you follow third, now 1 and 2 will tell you are wrong. So everywhere inconsistency started. If one condition, another condition is subject and very easy. Are you understanding or not? Now there is one meaning for this. There are two, three meanings. Two, three meanings. Then literal interpretation you should not do. Harmonious construction we should do. When there are multiple provisions which cannot be reconciled easily. Reconciled means all three giving a same. For example, date 1 to date 2, date 3 give only 31, 12. Very good. They are reconciled. Okay, they are managing with each other. There is no conflict. If there is a conflict between the sections, you should apply both the sections or both the provisions. Sir, if really lawmaker really find that, okay, any of this point is waste, why he will write? You should prepare, you should interpret in such a way that all the conditions should be given effect, all the provisions should be given effect. That's what you learn now. That's how you written how to do. Listen, I will ask a question. See here. Use common sense and answer. Nothing more than that is required. Nothing more required. Just to use a sheer common sense and answer. Okay? Nothing more required. Just a common sense. For example, I conducted my meeting on 12/9/24. Let's say I conducted my meeting on 12/9/24. Now you answer to my question. If I conduct a meeting on 12/9/24, now the question is, you take one condition. It comes to 31/12. It comes to 31/12/25. Okay. For example, I said first date is the date of next AGM. In that case, you are not following condition 2, you are not following condition 3. I repeat one more time. Don't get confused. Listen. 3 dates came. 3 answers came. All the 3 dates you can't conduct AGM. Na? Any one date only you should choose. Which one date? First or second or third? Question will arise. In that case, go by harmonious construction. None of the sections should get defeated. None of the sections should not be given no effect. Every section, every point should be given effect. Such that declare a date. If you say 31/12/25 is the last date, then it is after 12/12, it is after 39. Two provisions are getting defeated. Sorry. If you tell 12/12/25, condition 1, 31/12 is the last date. You are conducting on 12/12 within the time limit. 12/12 you are conducting within the time limit. 39, it is not within the time limit. You should conduct within 39. But as for this is the date. In this case also what is happening? Last point is getting defeated. Okay. If you take last point 39/25 as a last date, it satisfies all the 3. If you conduct the meeting on 39, it is within 31/12, it is within 12/12, it is within 39. Therefore, how to harmoniously construct this? That's why for section number 96, 3 dates are there. Date number 1 AGM in every year, gap not exceeding 15 months, within 6 months from the close of financial year, whichever is earlier should be the last date. The word whichever is earlier is nowhere used in the section. With a harmonious construction, people interpret that it is whichever is earlier. Now it's time for you to answer, understood or not. Okay. Now, so harmonious construction over. Next one, understanding the concept of marginal notes. Understanding the concept of what here? Marginal notes. Sir, what is a marginal notes? From here, let me be very quick in answering. Listen carefully. What is a marginal notes? This concept of marginal notes is not used in India anywhere today. Only in one we have marginal notes. That is Constitution of India. Constitution of India la marginal notes are given. What is a marginal notes? Summary of the entire section. Summary of a entire section is called as a marginal notes. Marginal notes is used as a tool for interpretation in case of Constitution of India only. in any other act, marginal notes can never be used as a tool for interpretation. Sir, why it is called as a marginal notes? It is written on the margins of the act. Left hand side margin or right hand side margin. Any act other than constitution, marginal notes are not used in India today. So marginal notes, generally people may tell that it will be used to interpret what is the overall idea of a section, but in other acts we are not using, constitutional we are using. So first read this. Marginal notes appended means added to the articles of the constitution have been held to be part of constitution as passed by the constituent assembly and therefore have been made use for construing the articles. Simple sense like we have to understand marginal notes to the articles, article number 370 like that will be there na. Marginal notes to the articles of the constitution are treated as a part of that act and it is used for interpretation of those articles. In regard to all other acts, marginal notes is never treated as a part of the act itself. Are you understanding? So, although there is a difference in opinion regarding resort to the marginal notes for construing an enactment, generally held view is that marginal notes appended to the section cannot be used for construing the section. Construing means interpreting the section. Okay, so marginal notes in an Indian statute, as in an act of parliament, cannot be referred for the purpose of construing the statute. And same view has been given, has been taken in many other cases. Many cases show that reference to marginal notes may be permissible only in exceptional cases and not in normal cases. Okay, please keep the heading in the notes. Please write down marginal notes. Though this concept is not practically used in India today, examiner 7 times this question came, including last 2 attempts back. So therefore write down marginal notes. Example, if a question comes, how to write that I am going to tell. 4 points we will conclude. Question will come for 4 marks. Okay, 4 to 5 marks they will give. Point number 1, write down. Point number 1. Generally, marginal notes to the section cannot be used for interpreting the section. Generally, marginal notes to the section cannot be used for interpreting the section. Okay, interpreting the section. Full stop. Next point. Though the same view is expressed by courts in various cases, in various cases, in some cases, exceptionally, marginal notes may be permissible. In construing a section. Next point. However, marginal notes appended to the constitution have been held to be a part of constitution, and therefore and therefore it is used to interpret the articles. It can be used to interpret the articles. Understood? That's it. With this, we have completed marginal notes concept also. Everyone reply. Are you all comfortable in understanding up to here clearly? Everyone? Next. Next one. How far title and preamble helps in interpreting any parts of enactment? First, let me explain the title concept. So, title does means there are two types of title. One is a short title, another one is a long title. Short title means it will just refer the law. It will just refer the law. Short title identifies the enactment. Like this, you have to write in exam. Short title will identify the enactment. Long title will not just identify the enactment, but it will ascertain the object and scope of an act. Object and scope of an act. I repeat one more time. There are two types of titles. One is a short title and the one is a long title. Short title will merely identifies an enactment. Identifies a enactment. Long title will not just identify the enactment, but it will be helpful to understand the objective and scope of an act. Okay. Now listen to the reality. Short title means the name of the act. The Companies Act 2013. What it is? That means it is just used to identify. Okay. Identify. Oh, okay. This is Companies Act. Long title means it will not just tell the Companies Act. It will tell the purpose of that act. Now in the today's world, in today India, long titles are removed. In that place, a preambles came. Okay, in that case, preambles came. Preamble is a part of an act. It will be written before section 1, but it is a part of an act. Okay, so short title and long title are the two types of titles. Two types of titles. Short title and long title are the two types of titles, and short title will merely identify the enactment. Merely identifies the enactment, but long title will not just merely identify. Okay, it will be used to understand the scope and objective of an act. Next, preamble. Preamble is a proper long title. Long titles are not there in India today. No act is writing long title. Once upon a time they used to write. Okay. Preamble. Preamble will be there for every act. Preamble will really express the overall objective and scope of an act. Expresses the scope and objective of an act more comprehensively than a long title. That's why long titles are removed. Anyway, preamble is there, na? Okay. Preamble may now tell me. Preamble will be telling what? Reciting what? Will recite the ground, means the purpose and the cause for making the statute. What is the purpose of making it and what evil it want to be remedied. Evil means not devil, I told you. Legal word evil is different. Okay, evil does not mean devil evil. Evil means a wrongs. Wrongs which it wanted to cover. Okay, for example, there is an act. What is the purpose of this act? These are the mistakes going on. We wanted to stop them. Okay. Preamble, like the long title, can be legitimately used for construing it. However, preamble cannot override the provisions of the act. Sir, preamble is like a reception to a company. Okay, what reception can do? Reception will tell overall what this particular thing can do. For example, reception, if you ask something, they will tell yes, this is the thing. That does not mean inside whatever reception said that only should happen. Reception will be understood to have a overall idea about what is this particular office premises. That does not mean if you can't do anything beyond the reception law what they said. Clear? Reception to the act is a preamble. Preamble can be used to understand the act. It will be used to interpret the purpose of law. But that does not mean that all sections in the act should be as per the preamble. Am I clear? So preamble is something they will tell. Act they will write so many sections. You should not tell each and every section should be taken from preamble. That can never happen. Okay? Everything in an office can't go as per reception. Like that, every section in the act can't go as per preamble. Preamble can be used to interpret the law, but that does not mean act should be as per preamble. Act overall will be as per preamble. Every section need not be. So, preamble cannot override provisions of the act. Only if the wording of the act give rise to the doubts as to the proper construction. Example, the words, etc., whatever. If there is any two meanings that are coming, preamble can be used to arrive at a proper construction. So, what to write in exam? That's the important thing. Title. Titles are of two types. One is a long title and the one is a short title. Short title will merely identifies the act, but long title will not just merely identify. It will explain objective and scope. 2 marks, okay. Next to 2 marks, preamble. Preamble will always tell about the purpose of the law, purpose of the law, object and scope of the law, more comprehensively than the long title. Preamble will be used to know the ground and cause for which the law is made and the evil it wanted to suppress and remedy. Clear? Next. Next one. Preamble, however, cannot override the provisions of the act. When there is an ambiguity in understanding an act, preamble can be used as a tool for interpretation. Like this, you can write and close. Reply. Understood the preamble concept clearly? Everyone, clear? Okay. Okay. Difference between interpretation and construction I will discuss separately. Last slide will discuss about it. First, let us go to mandatory provision and directory provision. Mandatory provision and directory provision. What factors decide whether a provision is directory or mandatory? Directory or mandatory. First, I will explain the idea. After that, we will go into the provision and read. First, listen carefully. Whenever section uses the word may, whenever the section uses the word may, section is called as a directory in nature. When a provision is a directory, when a provision is directory, when a provision is directory, it may be done, may not be done. It may be done, may not be done. Or if you comply with that section on a substantial level, okay. You need not everything do as per it. That's called as a directory provision. Directory provision means you need not comply with the section fully. Substantially, if you cover that particular compliance, na, very good. We are okay. Mandatory provision means it should be strictly observed. So 2 points completed here. What is the distinction between a mandatory provision and a directory provision? The distinction between a mandatory provision and a directory provision is, okay, in case it is the one which is a directory is that when it is mandatory. Okay, I will explain this way. Practically speaking, distinction between provision which is mandatory and one which is directory is that when it is mandatory, it should be strictly followed. If it is mandatory, the difference between mandatory and directory, when it is mandatory, strictly followed. When it is directly, you need not strictly follow everything, substantially you follow. 1 point over. What is the first one? The difference between directory provision and mandatory provision. Mandatory strictly follow, directly substantially follow. Okay, next. However, we have to look to the substance and not the form. An enactment in which mandatory form might substantially be directory, and conversely in a statute directory may in substance it is a mandatory. Sir, what is this? Sir, I didn't understand. Simply, whether a section is a directory or mandatory should be understood from the substance, not from the form. Substance over the form. Okay, sir, may means optional, shall means mandatory. Like that, you should not read always. Okay, sometimes we have to treat a mandatory provision as a directory provision, directory provision as a mandatory provision. Conversely means in a reverse. Okay, next. Hence, it is the substance that counts and must take precedence over the mere form. If a provision gives a power coupled with duty, it is mandatory. Whether it is or is not so would depend on such consideration as the nature of the thing empowered to be done, the object for which it is done, and the person for whose benefit the power is so exercised. Instead of all those, we can read up to here. Okay. First point number 1. I will make out the points for you to write in exam for that 4 marks. First point number 1. Distinction between Mandatory and directory. Directory is when it is mandatory, we should strictly follow. When it is directly, it is sufficient if you follow substantially. One point. Point number two. We should always go look into the substance and not on the form. Point two. Okay. Sometimes mandatory form may be directory. Directory form may be mandatory. Point 3. Depends on the situation sometimes. Hence, substance that counts over the mere form. The point number 4. Point number 5. If in a provision, power is coupled with duty. What do you mean power coupled with duty? When you have a power, authority has a power. Along with the power, there is a duty also. Okay? Then you should go not by your power, you should go by your duty. So, coupled with duty, it is mandatory. Power means what? May. Means I may exercise the power, I may not exercise the power. But must exercise that power. There is a duty to exercise that power means that power, though it is looking like may, it becomes mandatory. That's it. Okay? Next. Already we read grammatical interpretation. What we read in grammatical interpretation? Grammatical interpretation will be going as per the verbal expressions of the law. It does not go beyond the letter of law. Okay? In ordinary cases, grammatical interpretation is a sole form available. When the letter of law is logically defective, resulting in ambiguity, inconsistency, repugnancy, etc., then you will be traveling, court will travel beyond the letter of law. All these we already completed. Next. Proviso explanation. The other two things we are going to learn now. What is it? Proviso and explanation. So what is a proviso? What is an explanation? Let us try to understand it clearly now. Proviso. What is a proviso? Proviso is always used to create an exception. Okay, it's a condition. Proviso can be either used to create an exception or it can be used to create a condition. Okay, in an agreement. What is an explanation? Listen carefully what is an explanation. In the Bare Act, you will see the word explanation. For example, there is a section. For example, there is a definition. In that there are some technical words. Those technical words are defined by explanation. Okay? Explanation will not expand the scope of section. Explanation will not reduce the scope of section. Explanation will only explain the meaning of a particular word in the context of that section. I repeat one more time. Explanation do not expand the scope. Explanation do not reduce the scope of a section. It will only explain the meaning of the text in a particular section. Are you understanding or not? For example I will tell you. So many explanations are there. Which explanation I should explain? See here. For example, there is a section called as a holding company, subsidiary company. In that definition, they use the word company, holding company, subsidiary company. Explanation will be there below that. Do you know what is explanation they will give? The word company includes a body corporate. The word company includes a body. This is the explanation given. From this, what you have to understand? They are not expanding the scope of the section. They are saying that the word company used in this section only represents, in this section only, the word company includes body corporate also. What also? Body corporate also. So, from this, what you have to understand? When you are reading the definition of holding company, subsidiary company, to the word company also add body corporate. Also the body corporate. Nowhere you should remember that. You should always remember that in no way explanation cannot expand the scope of the main section, cannot reduce. Okay, it can only define the meaning. An explanation is appended to a section, means attached to the section to explain the meaning of the text, meaning of the words. Meaning of the words in the act can be defined in two ways. One, section 2 definitions. Number 2, every section has explanations. An explanation may be added to include something or to exclude something. Okay, here the word company includes body corporate. Now this is an inclusive explanation. In some sections they will tell in this will not come. That's an excluding explanation. Next, an explanation should be normally be so read as to harmonize with the with and clear up the ambiguity in the main section. Main section la doubt is there. For that word, there is a definition. That's it. For that only you should read explanation. It should not be construed to widen the ambit of the section. Ambit means the scope. So explanations won't increase the ambit of the section. That's it. Next. Next question I will take question number 13. Question number 13. Okay. Now, before going into section number 13, hope every one of you have a clarity up to here or not. So next one, let us see this. Explain the meaning of the term proviso. Proviso in an agreement is a condition, but proviso in the act has a different meaning. Give the distinction between proviso, exception, and a saving clause. Proviso, exception, and a saving clause. Let me first explain how to bifurcate. In an act, when you are reading, how to understand which is a proviso, which is a exception, and which is a saving clause. That we need to have a clarity, correct? Let's understand. Explain the meaning of the term proviso, exception, saving clause. Let me explain this. Proviso will be used for two purposes in the act. Proviso will be used either to provide an exception, Proviso can be used to create an exception to the main provision, or proviso can be used to add extra qualification. Whenever I say qualify means putting additional burden, additional duty, additional obligation, or additional condition. You can tell that way. So proviso will be used to do two things. Proviso can be used to either create an exception, or proviso can be used either to put more qualification to the section. Okay. So proviso is not always used to accept. Proviso can be used to accept something from the main section, main part of the section. Okay. Main part of the section they may use. Or proviso can be used also to put additional condition. Okay. I will give an example. General meeting chapter they will say this way. Notice of a general meeting must be given. Notice of a general meeting must be given to all the members of the company within not less than 21 clear days before the meeting. Proviso they say provided that a company may give shorter notice. What do you mean shorter notice here? It's an exception. It's an exception. Completely the section is not exempted. What they said is generally you need to give 21 days before. However, sometimes in emergency situation you may not follow the 21-day condition. In that case, you can give less than 21 provided you take approval of shareholders. Like that they will tell. Proviso is used to create an exception there. However, sometimes proviso can be used not only for an exception, sometimes proviso will be used to put additional condition, additional qualifications also proviso can be used to have. Okay, means what? Sometimes proviso, a section will say something. Proviso will tell provided that company shall file with the ROC. For example, prospectus is there. Prospectus what they will tell? Company, whenever it goes for a public offer, allotment must be completed. Okay, proviso they will provided that company has to file form PAS3 with the ROC within 30 days of allotment. What does it mean? Now proviso is not used as an exception, it is used to qualify the main section or subsection. Subsection is there below proviso. Subsection of what they said, company must complete its allotment within 60 days of the receipt of application money. It's provision. Below that proviso, what they will tell, whenever the allotment is completed within 30 days, you should file PAS3 with ROC. What is this? This is putting additional qualification to the subsection. That's the proviso. See now. Normal function of a proviso is to accept something out of the enactment. Okay, or to qualify something stated in the enactment. Enactment means a section, section, subsection, clause, subclause, all these things. All together we call as a provision or enactment. Okay, so to accept, to provide an exception from the enactment, or to qualify something stated in the enactment. Okay, which would be its purview if the proviso were not there. Okay, next. The effect of proviso is to qualify the preceding enactment. Means what? One point is there. Below that proviso will be there. Section can't start with a proviso. Already one thing is there. Something is written. Below that, provided that proviso will be there. This is called as a preceding one. This is a succeeding. Proviso succeeds the preceding provision. That's why The effect of proviso is to qualify the preceding enactment which is expressed in terms which are too general. Means what? Complete if you complete your allotment, if you complete your application money collection within 60 days, go for allotment, or else refund your money within 15 days. So complete your total thing within a period of 60 days. It is general. However, you should not just follow this. You should also file with ROC. This is additional qualification. As a general rule, a proviso is added to an enactment to qualify or to create an exception. Every word, repeatedly, they are using the same thing. In a simple language, I will tell you, listen. Exam, the question came. What you will write? The point you have to write is a proviso. Normally, the purpose of a proviso is to accept something from the enactment or to qualify something which is already stated in the enactment. Number one. The effect of the proviso is to qualify or to accept the preceding enactment. The preceding enactment is the concept. Next. Proviso is used as a interpretation rule. It is cardinal rule of interpretation, means important, noticeable rule of interpretation, that proviso to a particular provision of a statute only embraces means cover the field which is covered by the main provision. Means, for example, subsection 3 is there. In this one point is there. Below that I will write a proviso. This proviso will create an exception or qualification to what? To entire section or to entire act, only to this subsection. That's why proviso to a particular provision, here particular provision is subsection 3 of a statute, embraces, covers the field which is covered by main provision. For this only it is a proviso, it's not proviso generally. Okay, that's the point. These are the things you need to write. Next, difference between proviso, exception, saving clause. Proviso, exception, saving clause. By mistake it was printed. Proviso should come here, exception should come here. Okay, so let's understand the meaning now. Let us see the first one, the proviso. Distinction between the proviso, exception and a saving clause. Okay, so what is the possible difference between a term proviso, an exception and a saving clause? Proviso. Proviso is used to remove special cases from the general enactment and to provide them specially. Okay, proviso is used to remove special cases. Means what? Generally, whenever application money is received or whenever notice is to be given, 21 days before you should give the notice. It is general. Okay, I wanted to provide a special thing which is not there in this. Okay, then you will create a proviso. That proviso creates an exception. Okay, proviso is used to remove special cases from general cases. Generally 21, but 14 lesser than 21 is also possible. Therefore, proviso will come. Am I clear? Therefore, general points will be in subsection, special points which is either exception or additional qualification will be inserted in the form of a proviso. Next, this is proviso. Here it should be, here it should be. Now, exception. What is an exception? Exception is intended to restrain enacting clause to the particular cases. Means, in the section itself they will tell, not in the proviso. Sometimes they will tell, sometimes they will tell. For example, small company definition is there. And a company, small company. Small company means a company other than a public company. In the section itself they exempted it. So there is no need of proviso now. Section A exempted means for small public company can never become small company. Public company can never become small company. Exception is intended to restrain, means prohibit the enacting clause to a particular case. Small company clause is not applicable for what? It's not applicable for public companies. Next, saving clause. Sir, what is a saving clause, sir? Whenever section uses the word save as otherwise provided, save as otherwise provided, save as whenever come, that's called as a saving clause. That's called as a saving clause. Saving clause is used to preserve from destruction of certain rights, remedies or privileges already existed. Sir, I didn't understand. Listen now. Listen. I will give you an example. Okay, I will give you an example. You can understand clearly. See, in your syllabus I am taking exams, I am not bringing something from air. Okay, just a minute. Okay, see here. Section number 6. See the provision once. Save as otherwise expressly provided in this act. Save as otherwise expressly provided in this act. Provisions of the act shall have effect, notwithstanding anything to the contrary contained in memorandum, articles, agreement, general meeting resolution, board meeting resolution. Sir, what is this? I'll explain. What they said in section 6, they said act will be more bigger than, act will have a overriding effect, act will have a overriding effect over articles, memorandum, articles, agreement, resolution passed in a general meeting, resolution passed by the board of directors. Means act like something is said in the memorandum, you cannot go against to that. Simply act said that you can form a company only for a, act said that you can form a company only for a legal object. Now in my memorandum objects clause I said my company wanted to have an object of sale and purchase of narcotic drugs. You cannot write. Why? Memorandum I have written in objects clause, so I can do. No, you cannot do, because act is prohibiting you. So generally act is having overriding effect over articles, memorandum, resolutions, etc. That is general. Okay. However, in some sections articles will override act. Articles will override that. Okay, most of the, array in your syllabus so many sections are there. Do you know what? Example, I will tell you one thing. Example, there is a section called as buyback. Company cannot go for buyback unless it is there in the articles. Company cannot go for issue of redeemable preference shares unless it is there in the articles. Company cannot restrict the voting rights of a member unless it is there in the articles. Means restriction of voting rights, there is a section called as 106. Okay, one, sorry, if I will show you directly, or else you can't understand. See here, I am opening this section number 106. Okay, see, markings are also there. Today only I am taking regular class na. In the today we discussed about this section only. Luckily we are discussing about the same. That's why see here articles was rounded off already. See, notwithstanding anything contained in this act, notwithstanding anything contained in this act, the articles of the company, forget about notwithstanding all this, the articles of the company may provide that no member shall exercise the voting right if the calls are due or lien is there on the shares. I'm not going to explain 106 to you now. Okay, I'm not going to explain 106. I'm going to tell you what meaning of save as otherwise provided. Okay, what they said, save as otherwise expressly provided in this act. Act will be overriding memorandum, articles. Act will be greater than MOA, AOA, agreement, resolutions in a general meeting, resolutions passed by the board of directors. This is what who said? This is what said in the act. Okay, section 6 said like this, using the word save as otherwise expressly provided in the act. Okay, so what do you mean by that save as otherwise? That is saving clause. Okay, meaning I will tell you. Here if you see section number 106, restriction on voting rights. A member will be restricted to vote in the general meeting if he do not pay the calls. If he do not pay the calls, he cannot vote in the general meeting. When articles provide for it. So if articles is not providing, that means in the articles you did not tell that non-payment of calls can be a ground to restrict the voting rights, then you cannot restrict the voting rights of a member even though he did not pay the calls. Means section 106 will be activated. Okay, if and only if It is there in the articles. Means section is subjected to articles or articles is subjected to section. Here in this case, section itself is subjected to articles. Now, as per general provision, act is bigger than articles. But here, articles is bigger than act. That's what the meaning of saving. Saving means this section should be saved. Okay. Normally, act is bigger than articles. But here articles is bigger than act. Now two sections are there. Two sections la, one section la, they only said in section 6 act is bigger than articles. Here if you read, articles is given more impact than act. Now sir, therefore that section la already they said na, therefore articles need not provide, act will override articles. Now this section is destructed, this section is damaged. Now that should not happen. Therefore whenever in a section I use the word save as, otherwise, okay, whenever articles is clearly saying that articles will give power to section, then the general rule does not apply and this section should not be destroyed. Articles will override the act if it is expressly said like this. Okay, so that's why saving clause is used to preserve. Preserve means save, okay, from destruction of certain rights, remedies, privileges already existed. Classic example, section number 106. 106 law already there is a certain right to the article. What is that? Article should give power to 106. Okay, that should be saved. Okay, against section number 6. So whenever a section use the word save as, otherwise, that section is lesser important than some other section. That's the meaning. Everyone in the class understood clearly? Reply. Everyone. Okay. Next. I will go little fast, listen carefully. Repeal of a provision different from deletion of a provision. Okay. Actually, this is from the General Clauses Act. But okay, no problem. Okay. Let's understand. Repeal different from deletion. Sir, what is a repeal? What is a deletion? See, if a section is deleted from an act, okay, if a section is deleted from the act, from the date of deletion, it will not have any effect. So, previous cases which are already there on that will work. Okay, for example, I said, from today, GST on, for example, tobacco and other products is 40%. Example, I am saying 45% I said. Okay, so delete the old provision, apply this I said. Delete the old provision means those who purchased the tobacco products before this should also pay the extra amount. Or I will tell this way. GST on so and so products exempted from GST, I said. Those who already paid previously, they will be returned back with the money. No, that's a deletion. Deletion of a provision will take effect from the date of deletion. Repeal is different. When a particular provision or an act itself is repealed, it will be repealed from its beginning itself. That's the answer. In Naurangpura Gam, Dharmada Milka Trust versus, okay, Ramaji, it was held that it is decided that repeal of a provision is different from deletion of a provision. Okay, repeal ordinarily brings about complete obliteration of the provisions as if it was never existed. As if it was never existed, it will repeal, thereby affecting all incoherent rights and all causes of action related to repealed provision. Means even if any person is kept in the jail, he will also be released now in case of a repeal. While deletion ordinarily takes effect from date of legislature affecting the said deletion. Clear? Done. Okay. This is Pakka General Clauses Act question. By mistake it was printed. General Clauses Act. Next session I will discuss about it. Heden's case. I told now what is the law before making the act. What law did not provide for. What are the remedies the new act has provided. What is the reason for the remedy. That's it. Next. Same, whatever you are having, you need to read the same. Heden's rule means first, when the language in the law is capable of giving more than one interpretation, court should resort to such interpretation which will suppress the mischief, advance the remedy. That's it. Okay. It shall suppress the mischief, advance the remedy. Okay. So that's the point. If you want, you can read an example and you can write. Grammatical interpretation, I told you already. What is a grammatical interpretation, logical interpretation? Already we read, na? In order to ascertain the meaning of a statute, first we need to take a general grammatical meaning of that particular word. Okay, if the general word is okay giving a wrong meaning, then you should go by logical interpretation. So generally interpretation can be of two types. Number one, grammatical interpretation. Second one is a logical interpretation. Okay, grammatical interpretation focus on the verbal expression of the law. Logical interpretation will give intention of the law rather than the grammatical interpretation. Okay, generally sole allowable thing is grammatical interpretation, but if the grammatical interpretation results in an absurdity, it is given an inconsistency, then courts are bound to, or it has a duty to travel beyond the words of law and give a logical interpretation. Next, what is the effect of a proviso? Already proviso also we read just now. Next, okay, this is only a general question, not an exam question, so I am not giving more importance to this. Okay. How will you interpret the definitions in a statute? Means includes. Means includes. Whenever the definition uses the word means, okay, and give a list, only those things should come within the meaning of the term. Okay, all other things should not be given any importance. I repeat one more time. If a statute use the word, if a definition use the word means, only those things should come. Means always results in exhaustive and restrictive. You have no authority to add anything or delete anything. It should be read as it is. Court will not allow you to add anything or modify anything. As it is, you read. Related party means I have given a list. Only those are the list. Relative list was given. Those a list. That's it. You cannot add anything, delete anything. Includes, on the other hand, is extensive and inclusive. Means what? Whatever the list I have given after includes, those are also some of the examples. Those are not the only. So means always associated with only those will come. Includes always associated with also those will come. Okay. Interpretation of the words means and includes. The definition of a word or expression in the definition and definition section may be either restricting or extensive. It may be restricting or extensive. Okay. Whenever I use the word means, it is restrictive, exhaustive, and must restrict the meaning. But where the word is include, it is extensive, and illustrative. Illustrative means those are only examples. Next, examples, you write any two examples, you know. Next, mandatory provision and directory provision. Just now we discussed. Okay, mandatory provision, directory provision, we read na. Whenever, strictly speaking, mandatory provision means there are two types of provision. One is a mandatory provision and one is a directory provision. When it should be strictly followed, it should be called as a mandatory. And substantially, if you follow, it will be called as a directory provision. Understood? So one has to see the substance, not the mere form of a particular section. Not a mere form of a particular section. When sometimes directory provision, section may be directory, but originally it is by form it is obligatory. Okay, so it is, though it is looking like a directory, it's a mandatory. Sometimes mandatory provision should be interpreted as a directory provision depending on the context. Okay, so therefore the final thing what we read, when a power is coupled with duty, okay, though it is a power may or may not exercise, when duty is attached to that, you should read it as a mandatory provision only. Understood? Next, grammatical interpretation also again repeated. Preamble, again we read. Okay, preamble always tell about the object of bringing a particular law into existence. All these things you need to understand. Next, dictionary definition. First question we read dictionary definitions. Okay, whenever you want a particular word, first read the law. If the law has no meaning for that, then you can go and read the definitions and give a general meaning in which it is commonly used. Okay, but when you are selecting one out of more options, you should be careful in selecting a right thing in the context in which you are making. Okay. Next, preamble does not override the plain provision of the act. Okay, preamble cannot. I told now already, preamble is like a reception. Preamble is always talking about the object and scope of a particular law. It will always tell about the objective and scope of particular law. Whenever you are writing a law, the objective and scope will be defined in the preamble. Preamble can be used as an internal help of an interpretation, no doubt. However, preamble cannot override the plain provision of an act. But if the words of a statute rise to doubts, then, for example, where the words of a phrase has more than one meaning and doubts arises, then preamble can be used to have a proper construction. This is all example. All example. Next, let me cover the most important one. Again, dictionary definitions completed. Mischief rule already completed. Grammatical interpretation, logical interpretation completed. Natural and grammatical meaning completed. Harmonious construction completed. Marginal notes completed. Title and preamble completed. Next. Okay. Let us see a new question now. 35. What is this? Associated words to be understood in a common sense manner. When two or more expressions are coupled together, one of which generally excludes the other, obviously more general term is used in the meaning excluding the specific one. On the other hand, there is a concept of Noscitur a sociis. It is known by its associates. That is to say, the meaning of the word is to be judged by the company it keeps. When two or more words which are capable of analogous means similar, okay, the meaning analogous meaning are coupled together, they are to be understood in their cognate sense, means in the same sense they should be understood. They take as it were their color from each other. The more general is restricted to sense analogous to less general. Sir, what is this, sir? Very difficult to understand. Very easy. First read this particular text properly. I will give a small notes for you to understand this in an easy way. Read it first. Read it first, we will go into analysis. Read properly first. Understood? Have you read? Okay, listen first. So listen. Hope you read this before you are starting. When two or more words or expressions are coupled together, one of which generally excludes the other, obviously the more general term is used in the meaning excluding the specific one. Excluding the specific one. When two or more words and expressions are coupled together, okay, when two words are coupled together, added together, okay, of which one of which generally excludes the another, okay, obviously the more general term is used in the meaning of excluding the is used in a meaning excluding the specific one. On the other hand, there is a concept of Noscitur a sociis. Noscitur a sociis means it is known by its associates. That is to say, the meaning of a word is to be judged by the company it keeps. When two or more words are capable of analogous, which are similar to each other, are coupled together, they are to be understood in their cognate sense. Okay? They take their color from each other. The more general is restricted to a sense analogous to the less general. It is a rule wider than a rule of ejusdem generis. Rather, ejusdem generis is only an application of Noscitur a sociis. It must be borne in the mind that Noscitur a sociis is merely a rule of construction and it cannot prevail in cases where it is clear that the wider words have been deliberately used in order to make the scope of the defined word correspondingly wider. Sir, I didn't understand also this. Again, 1 minute time. Read also this paragraph. Sir, this is an expected question for the Jan 25. So please be careful when you are reading. Given in latest RTP also. Okay. Now listen. Listen, I will explain the point first. Listen. Noscitur a sociis is an expected question for the Jan 25 exams. First thing that I wanted to confirm. If the question comes in exam, don't blame me. So I am repeating once. Okay. Listen. Generally, when multiple words are used in a context, every word has a meaning, and we will give a general meaning to the words used. Okay. For example, I said the names of some animals. Okay. Lion, tiger, leopard. Like that I am saying. Lion, tiger, leopard. Lion, tiger, leopard, and other birds. Other birds means lion, tiger is not bird. Other birds means the lion, tiger, and leopard. Like that I said that those are all wild animals. See here what he is saying. When two words or expressions are coupled together, two words. Here, for example, wild animals and birds. I used two words. Okay, one of which generally excludes another. Yes, wild animals don't include normal birds. Obviously, more general term is used in meaning excluding the specific one. Here, try to understand. And wild animals means wild animal. Birds means any birds it can be. Okay, it can be domestically grown birds or even a wild one. Anything it can be. So two things will have two different meanings now. Generally, when the two words are coupled together, first in exam, if a question comes, what you have to write? When two or more expressions are coupled together, means used together, one of which generally excludes other, obviously the general term, okay, will be giving more meaning and exclude the specific one. On the other hand, there is a concept called as a Noscitur a sociis, which says that whenever the words are used, the word which is used at the last should take the should take the color from the previous specific words. Sir, I didn't understand what it is. Sir, I will give you one example for you to understand. Okay, I will give an example. In a law, they said like this: lakes, rivers, streams, and other water bodies. I will write lakes, rivers, streams, and other water bodies. If I use like this, lakes, rivers, streams, and other water bodies, I use the word lakes, rivers, streams, and other water bodies. Other water bodies means what? Other water bodies should be in the nature of lakes, rivers, and streams which are naturally created, not man-made, artificially created things like swimming pools and other water tanks. Okay, because the words which I am using, lakes, rivers, and streams, and other water bodies I am using. When I use other water bodies, which water bodies? In what context I am using it? Generally, lakes, rivers, streams, and other water bodies means lake, river, stream, or any other water body. But not like that. You should take the color from. Okay, you should take the color from each other. lakes type of water body, river type of water body. Okay, ponds will come. Okay, but streams will come, but not swimming pool and water tanks, because those are also water bodies. But the context in which I am reading are naturally formed water bodies. Are you understanding the point or not? So therefore try to understand clearly. See here, when two or more words or expressions are coupled together, one of which generally exclude another, obviously more general term is used in the meaning. One point over. On the other hand, there is a rule called as a Noscitur sociis. Noscitur sociis means what? It is known by its associates, other attached things. That is to say, the meaning of a word, here water bodies, is judged by the company it keeps, is judged from the previous words you are using. For example, in a police complaint, I written like this: I lost my bag. I lost my bag containing. Example I am telling, no one will give like this. Example. Okay, I have written like this: my bag containing toothpaste, toothbrush, towel, and oil is missing. Okay, and oil is missing. Oil, I said. Which oil, yeah? Huh? Engine oil. What in what context I am saying? I am saying very clearly my bag containing toothpaste, toothbrush, towel, and oil. Okay, hair oil it represent. It's not cooking oil. It's not engine oil. Understood? So the word should take the meaning from the company it keeps, from the associate words. This is similar to ejusdem genres. Ejusdem genres also same. Ejusdem genres a small difference. There are specific words. Specific words are closed by a general word, etc., so on, others. That other, so on, etc. should take the meaning from previous word. Here word A will be given, there word also will not be given, others, etc. will be given. So Noscitur sociis is a more wider interpretation concept which includes ejusdem genres into it. Okay. Next. It is a rule wider than the ejusdem genres. Rather, ejusdem genres is only an application of Noscitur sociis. Okay. Noscitur sociis is not an application of ejusdem genres, is one of the way of Noscitur sociis. It must be borne in mind, kept in mind that Noscitur sociis is merely a rule of construction, and it cannot prevail in cases where it is clear and wider words are deliberately used. For example, government intended to really tell any kind of water body. In that case, other water bodies should not be only lakes, rivers, etc. Any water body, swimming pools and water tanks also will be allowed. Am I clear? Clear everyone? For example, government wanted to impose water meters on water coming from lakes, streams, ponds, and other water bodies. Tanks also will be included into that, though it is not man-made, because government intention was to use wider words. Okay, see here. It must be borne in mind that Noscitur sociis is a merely a rule of construction. Okay, construction means what? When words are unclear, then only you should do that. It cannot prevail in cases, means it will not work in cases where it is clear that wider words have been deliberately, intentionally used in order to make the scope of the defined word wider. If government intention is to really include that, then you should not tell Noscitur sociis, artificial water bodies should not come. Government intention is to include them. Okay, now everyone reply. Understood the concept clearly? Fast. I want a reply. Okay. Done. Next. Means and includes already completed. Usage and practice we all read in the general clauses. Hidden case already over. Interpretation versus construction. I said at the last, before we close this chapter, I will tell about that. Directory provision, mandatory provision over. Grammatical interpretation over. Proviso explanation over. Ambiguous definition subject to contrary. This we need to read. Okay, let's read. What is the next question? Ambiguous definitions subjected to contrary context. Okay. Ambiguous definitions. Let us read first. Sometimes we may find that definition section may itself be ambiguous, and so it may have to be interpreted in the light of other provisions of the Act, and having regard to the ordinary meaning of the word defined. Such type of definition is not to be read in isolation. It must be read in the context of the phrase which it defines, realizing that the function of the definition is to give accuracy and certainty of the word or phrase which would be otherwise be vague. Vague means unclear and uncertain, but not to contradict it or to depose it altogether. But very definition, very difficult sentences they use now. We'll make it simpler. Take a minute time, read it first. Read it first. Okay? Listen. See, in reality, in the Companies Act or any other act which has made now, no ambiguous definitions are there. Ambiguous definitions means what? Ambiguous means unclear. Definition itself is unclear. Okay, now lawmakers are not writing that way. They are making all the definitions very clear and interpretative. However, in some of the acts, the words of the act are unclear. Okay, it will give a abstract result, it will give a ambiguous meaning. Means whether to interpret like this or like this, a question will arise. Are you understanding the point or not? So a doubt will come as to how to interpret that particular word. Those definitions where when you read, clarity will not come. See, I will tell you one general English statement for you to understand. I saw a man with a telescope. I saw a man with a telescope. This is a general English word, English phrase actually, rather. I saw a man with a telescope. Now you should understand, I saw a man with a telescope. This can give two meanings now. Number one, a person is carrying a telescope, a man, I saw him. Or I saw a man using a telescope. That meaning also will come. Like this, no statements are written in the law now to confuse you. But actually, if there is any confusion like this, that means if you read the sentence, it's giving two meanings. How to interpret, we are not understanding. Those are called as ambiguous definitions. In Companies Act, there are no ambiguous. Okay? Sometimes, that's why. That concept is doubtful. Companies Act, it's not there. We may find that the definition section may itself be ambiguous. And so, it may have to be interpreted in the light of other provisions of the act. And having regard to the ordinary meaning of the word defined. So, whenever the words are ambiguous, don't read that word in isolation. That's why such type of definition is not to be read in isolation. It should be read along with the other provisions of the act and give a right meaning according to the context. It must be read in the context of the phrase which it defines, realizing the function. Function means purpose of the definition, to give accuracy and certainty to the word. So that's what you have to remember for the exam point of view. Okay. Again, I repeat, ambiguous definition. How to understand? Sometimes we may find that the definition section itself is ambiguous. Okay. So, in order to be interpreted properly, you have to give the ordinary meaning for that. Such type of definition should not be read in isolation. They should be read in the light of other provisions of the act to give the right meaning to the word and the function for which it is provided to maintain accuracy and certainty. Next, definition subject to the contrary context. Okay, I will explain you the point. Sir, what is this? Sometimes section definitions are used like this. Unless the context otherwise provide. This is the definition. What do you mean by that? I will give you super duper example. See here. Definitions. In this act, unless the context otherwise require. Okay, so 1 second. Battery is dead. Just a minute. We'll be back. It's 2 minutes. See here. In the definition itself, they clearly said, in this act, unless the context otherwise require, like that they said, some definitions are given. What do you mean by unless the context otherwise require? These are all the definitions given. These are all the general definitions. If in a section these words are defined in a different way, follow that only. In that context they are defining in a different way or not, follow that only. If nothing is defined differently from this, follow this. If the context, if they defined it in a different way, follow that only. Classic example, foreign company definition. See. Or I will give you an example here. See here. Foreign company. Okay. See. Latest, this also we discussed in regular class. So anyway, foreign company defined. What is a foreign company? Foreign company means a company incorporated outside India, has a place of business in. Yesterday only we completed, na? Foreign company means a company incorporated outside India and having a place of business in India. Two conditions ought to be satisfied. Okay? But there is a section called as section number 234. What is a foreign company? Company incorporated outside India. This also we discussed. That's why again round off is there. Okay, in class in regular sessions, like interpretation of statutes is a part of the act. It's not as a separate chapter. But revision class, like there is no option we have to discuss. That's why all rounding off is already there. Foreign company, see here. In section 234, merger or amalgamation with a foreign company. What is a foreign company? Generally, foreign company means a company incorporated outside India having a place of business in India. That's the meaning. However, in this section, they clearly said in explanation. Okay, I said na explanation will exclude something or exclude the meaning or include something to the meaning. For the purposes of subsection 2, the expression foreign company means any company or body corporate incorporated outside India, whether having a place of business or not. Place of business is not mandatory. Under which section? 234. Now this is the context otherwise providing. Means whenever the context differently they provide, follow the different one. Or else follow the definitions. That's the meaning of definition subject to contrary context. Where a word is defined to bear a number of inclusive meanings, the sense in which it is used in the particular provision must be ascertained from the context of the scheme of the act. That means generally foreign company means they have given the list. That is general. But in a particular provision, if they use differently, it should be ascertained from the context. In the context of subsection 2 of section 234, the foreign company details that are given in section 2 clause 42 should not be considered. The language of the provision and the object intended to be served thereby. Okay. Next, this is again, we will discuss interpretation of documents along with General Clauses Act. Proviso we completed, explanation we completed. Ejusdem generis. So what is this ejusdem generis? There are, see, the rule of ejusdem generis applies when statute contains enumeration of specific words. Lion, tiger, leopard, okay, specific words. Subject of enumeration consists of a class or category. These all belongs to a common class, wild animals. That class or is not exhausted by enumeration. You should not tell the list of all wild animals. If you tell all the wild animals list, then there is no need to use etc. That's why. The specific enumeration should not exhaust. Exhaust means should not complete the enumeration. General terms follow the enumeration. Etc. is a general term. E3 specific term. There is no indication of different legislative intent. Then, lastly, write down. Then, general word should be interpreted from the specific words. I have a fear towards lion, tiger, leopard, etc. Or lion, tiger, leopard, so on, etc. will be meaning meant to say what? Lion, tiger, leopard, mosquitoes, flies, okay, hen, ada. No. The word etc. should take the meaning from the previous specific words. That's the meaning. Next. Historical setting, use of foreign decisions. Okay, listen. What is the importance of following terms in external aid of interpretation? Sir, what is internal aid, external aid? Internal aid means within the law itself, those will help us. Proviso, explanation, all these are in the act. They will help us. External aid means these are not in the act. We should see other things and understand the interpretation. Means what? Historical setting. Which setting? Historical setting. Means what? Whenever you wanted to understand any law, you should understand the past history of that law. Okay, that's why whenever I discuss about law, I will tell about what is there in the past, what is there today, such that you will really understand why that particular section came. The history of the external circumstances which led to the enactment in the question is of much significance in construing any enactment. Why this act came, if you know what is happening, na, section's interpretation is very easy. We have for this purpose to take the help from all those external or historic facts which are necessary in understanding and comprehension of a subject matter. History in general and parliamentary history in particular, ancient statutes, contemporary or other authentic works and writings you need to consider. All these things we need to consider and then interpret the law. Use of foreign decisions. Sir, foreign decisions can be taken or cannot be taken. Yes. Solomon versus Solomon. Who is Solomon? He is from Chennai. Nungambakama, Rayapeta. Okay. From where he is? He is from London. But still we are applying the cases now. Foreign decisions can be used or cannot be used? Can be used. Foreign decisions of the countries following the same system of jurisprudence. Companies Act in India, England, same as ours, and given on laws similar to ours, legitimately used to construing our own acts. However, prime importance is always given to the language of the Indian statute. Though Indian statute should be given more important, if the jurisprudence means the foundation on which both the laws are there, if they are same, you can take the foreign decisions into consideration. Next one. Whereas a director of a company, not being personally concerned or interested financial or otherwise in a matter of a proposed motion placed before the board meeting, did not disclose his interest, although he has a knowledge that his sister is interested in that proposal. He restrains from making any disclosure of his interest on the presumption that he is not required by law to disclose any interest as he is not personally interested or concerned in the proposal. He made his presumption relying on the rule of literal construction. Explain the scope of interpretation under this rule in the given situation. Decide whether decision of Viraj is correct. read the question properly first before we go into solution or analysis. Read the question. Okay, let's see. Sir, what is this section all about, or what is this concept all about? So there is a section in Companies Act. That section is not there for CA Inter actually. Okay, but that does not have anything to do with your examination. They will ask question. Okay, because they are not going to ask any question on that section. They are asking on interpretation of that section. Viraj, a director of a company. So simple. Whenever a director is involved in any transaction, either directly or indirectly, means directly he is the party to the transaction. Okay, related party transaction. Director is entering. He should tell to the board members that he is interested. Okay, if his relatives are interested, then also he should disclose. See, Viraj, a director of a company, not being personally concerned or interested, financial or otherwise, in a matter of a proposed motion placed before the board meeting, did not disclose his interest, although he has a knowledge that his sister is interested in that proposal. For example, I am the director, my sister is there. Okay, my sister is my relative. My relative, sister is a relative under Companies Act. Company entering into transaction with my sister. Okay, I am not involved in the transaction. My sister is involved. My sister and me are two different parties. We are belonging to the same family, and we are the siblings. So obviously, she is called as a related party. Okay, what they said. Viraj, a director of a company, not being personally concerned. Here, concerned or interested, financially or otherwise, means either interested directly or indirectly through your relatives is also covered. He knew that his sister is entering into transaction. He did not tell to the company that she is his sister. Company entered into transaction believing that she is a non-related party. Okay. Okay. Next, did not disclose his interest, although he has a knowledge that his sister is interested. He restrains from making any disclosure of interest on presumption that he is not required by law to disclose any interest, as he is not personally concerned or interested. As he is generally literal interpretation we need to make. Whenever the words are plain and unambiguous, give a literal meaning to that and interpret that and follow. But when the words of the section are not plain and clear, you said concerned or interested financially or otherwise. Okay, in any form. Otherwise means in any form. Any form means what? It may be directly or through indirectly through your relatives. So in that case, literal interpretation will not survive. You should go by reasonable interpretation. You should expand the scope of that word. Normally, where the words of the statute are clear and unambiguous, then these words should be construed in their natural and ordinary sense. And it is not open to the court to adopt any other hypothetical construction. Now, that is understandable. When the words of the law are clear and unambiguous, go by natural meaning. Okay, and court has no right to go for extreme interpretations. Okay, this is called literal construction. Next, this is not required, come directly to this. Sometimes occasions may arise when choice has to be made between two interpretation. Now, doubt come. Financially or otherwise means what? Generally, we need to read or we need to give a wider meaning to that. One narrower, one wider. In such a situation, if the narrow interpretation failed to achieve the purpose of list, what is the purpose of that section? Array, whenever you or your relatives are interested in a contract, tell to the company will at least come to know that okay, either director or his relatives are interested. For example, sister is not there, yeah, wife of a director is there. Director and wife of a director are two different parties. Are you understanding or not? Company entering into transaction with a director, company entering into transaction with the wife of a director, what difference will it make? Anyway, director is an interested party in that. Okay, I am not personally interested. You need not be personally interested. Indirectly interest also covered. Okay, one should adopt the wider one. When we talk disclosure of nature of interest, otherwise of a director or manager, the company of the company in the subject matter of proposed motion, okay, we have to interpret in a broader sense, referring to any concern or interest containing any information or facts that may enable the members to understand the meaning, scope, or implication. What is required is a full and frank disclosure without any suppression of the fact. In instance where a son or daughter or father or mother, brother or sister is concerned, shareholders should be informed about it. Like that you need to write. In this case, Viraj's intention that since he is not personally interested, he need not disclose is wrong. Okay, you need not be interested directly. Indirectly, if you are interested also, you need to disclose. Later you read that answer. Preamble already we completed. That's it. Yeah, these are all various questions that they are asking in this chapter. Interpretation of statutes. Don't miss the chapter. Repeatedly they are asking the same questions in examination. Okay. Lastly, I will tell about one answer. What is the difference between interpretation and construction? Later you read. Interpretation is a concept of giving a right meaning to the words used in the law. Construction is a concept of going beyond the language of the law, going beyond the words of law and achieving the intention of the lawmaker. Intention of the lawmaker means the word may not be given the same meaning, but lawmaker intention will be achieved in a construction. Okay, construction is going beyond the text. Simply to tell, logical interpretation is a construction, grammatical interpretation is a interpretation. Okay, later you read, write in a point wise format and remember that answer. In this chapter, most important thing is remembrance by the student. That is entirely the headache of the student only. I explained all the important context and concepts inside interpretation of statutes. Okay, so thank you very much. Meet you in the next session again. Everyone in the class understood the point clearly or not? Please put a comment.